Today I'm sharing with you the 7 things to never put in your will. Hi, I'm Pam Mosquera, an estate planning lawyer and wealth expert, and I'm on a mission to help you grow and protect your wealth. Now, if you've been following me for a while, you know that I talk a lot about the advantages of a trust over a will. And I'm going to include in the description a link to those videos so you can really understand for yourself. The thing to keep in mind is even if you do set up a trust, you're always going to have what's called a pour over will, which is there as a safety measure if for some reason you pass away and everything is not in your trust. So let's start with number 1, funeral and burial wishes. You should not put your funeral and burial wishes in your will because often a will is consulted much later after your funeral, and then it's too late. So you want to include those wishes in a document to your loved ones ahead of time. And I will say a lot of families I work with really love when their loved ones have taken the time to plan out their funeral and burial wishes. And I know it can seem a little morbid, you might not want to do it, but it does take a huge burden off your loved ones trying to figure out what you want down the road. For example, I've worked with families where family members fight over what they think their loved ones would want as a funeral, or whether it should be cremation or burial. You can plan all that out ahead of time and give that information to your loved ones to make it easier for them. Number 2, organ donation preferences. Again, this is something where the will is consulted later and it's too late. Instead, you want to have your organ donation preferences typically with your driver's license registry, selecting on your driver's license what your preference is. You can also include your preferences in your advanced healthcare directive, also known as a living will. Number 3, IRA and retirement accounts. These are accounts that you typically list beneficiaries. So if you list a beneficiary and then put something different in your will, the beneficiaries you list will trump anything that you write in your will. Now, if you have a trust, you're typically going to list your spouse as the primary beneficiary and the trust as the contingent. If you don't have a trust, you'll typically list your spouse first and your children contingent. Keep in mind, if you were to pass away when your children are minors, they can't receive that inheritance outright. It's going to have to go through court. That's where a trust is a major advantage, especially if you have minor children. Number 4, life support and end-of-life decisions. Again, a will is not consulted until much later, so if you have specific wishes around life support, end of life, you're going to want to put this in an advanced healthcare directive, also known as a living will. And you're going to want to set this up based on your specific state's laws. For example, here in Colorado, we have a very specific set of instructions and questions that you have to answer. And those questions and instructions are different than someone in, say, Arizona or California. So you want to work with a licensed attorney in your state to be sure you're answering the questions based on your state's laws. Number 5, assets in a trust. And this is where people often get things wrong. If you have a trust, all the trust assets should be written in the trust and documented in the trust. And anything that's accidentally left out, your will should state it should go into your trust and follow those instructions. Number 6, account numbers and social security numbers. Many people don't realize that when you pass away, your will becomes public record. And so you don't want to put sensitive information in the will because then that will be accessible by the public. So be sure to keep out your account numbers and social security numbers. Where should you put that? You should not put that in your will. You should include it in your estate planning folder, an inventory of everything you own and where people can find it. Number 7, emotional commentary. If, for example, you're disinheriting someone or you're very angry at someone, you should not put that information in your will. Why? Again, because a will becomes public and you want to keep all that stuff private. You don't want to air your family's dirty laundry or share sensitive information that could put your family at risk. Now, this is another advantage of a trust over a will. Trusts are kept private, but wills are public. So any emotional commentary you have or guidance or things you want to share with your loved ones, I'd recommend recording or writing those down and have those in your estate planning binder in a different place. If you like this video, you're likely someone who wants to have everything set up for your loved ones. You don't want to leave them a complete mess. That's why I recommend you head over to deadkit.com and download my Sorry I'm Dead, Now What kit. In that kit, I walk you through how you can organize everything in a way that sets your family up for success. Your passwords, all of your important information, so that when you pass away, your people know exactly what to do and it keeps them out of chaos. I'll see you in the next video.